Okay, so I'd like to call to order the Zoning Board of Appeals meeting for Monday, November 9th, 2020. It will be an electronic meeting tonight. So if we're ready for roll call, please.
Board Member
wait,
Allen?
Okay.
I'm sorry, go ahead.
No, I'm sorry. I thought, aren't we supposed to do the pledge next?
Yes.
Okay, so let's do the pledge first. I'm sorry. Everybody stand. I pledge allegiance
To the
to the
flag
flag of the United
States of America
and to the
and to
republic
the republic for
for
which
which
it
it
stands,
stands, one
nation,
under
under
God,
God,
indivisible,
indivisible,
liberty and
and
justice
justice for all.
for all. Okay, so now we will do roll call, please.
Board Member Allen?
Here.
Board Member Gesund?
Here,
Board Member Krug?
Here.
Board Member McAlpine? Ms. McAlpine?
Here,
Alternate McDonald?
Here.
Board Member Euler?
Here.
Board Member Ward? Chair Evans?
so for the record, we just want to note that the two zoning board of appeals, Mr. Evans and our other representative are not here this evening, so I will be the chair. So we will now take a look at the agenda, and we do need to go ahead and approve the agenda. Are there
Ms.
any?
McAlpine?
Yes.
We would need to, if we wanted to excuse any of the members that aren't seating this evening, we would need a motion for that at this time.
Okay, I'm sorry. So we need a motion to excuse our members that are not present.
move to excuse board members or board chair Evans and board member Ward.
I will second.
I have a question.
Yes.
Did they both call and let you know that they would not be there?
Mr. Evans, Chair Evans emailed me this afternoon, said he would be unable to attend. I have not heard from Ms. McAlpine, or I'm sorry, Ms. Ward.
Okay, do we want to excuse both? Because the rules are fairly clear.
Mr. Gazan, would you like to change your motion?
I guess we could separate them out.
That works.
Yes.
Okay, so we're changing it to excusing Chair Evans.
I'll second that.
All right, Gesund,
Yes.
Krug,
Yes.
McDonald,
Yes.
Euler,
Yes.
Allen,
Yes.
McAlpine.
Yes.
Now I'd like to move to excuse board member Ward.
I'll second the motion.
Krug,
No.
McDonald,
No.
Euler,
Yes.
Allen,
No.
Gesund,
Yes.
McAlpine.
Yes.
Well, we have a tie.
So what do we do? This
Is there anybody who would like to modify their motion?
I
I
guess,
don't know if this is permissible, but I I would modify the motion to table the issue of whether or not to excuse the absence till the next meeting. I have a pretty
Okay, I can agree with that.
Ms. Ward, and I have a pretty good idea that she's probably got a good reason, so.
Yeah, I would say at least give her 24, 48 hours to respond or something, or to the next meeting, however that works best.
Okay. Do we have a support?
I'll support. Oh,
McDonald,
Yeah, I'll support that.
Euler,
Yes.
Allen,
No.
Gesund,
Yes.
Krug,
yes.
McAlpine.
Yes. Okay, so then are we ready? Next up would be for us to review the agenda as it's been presented. And if there are no changes, we do need a motion to approve the agenda as presented.
Make a motion to approve the agenda as presented.
Support.
Euler,
Yes.
Allen,
Yes.
Gesund,
Yes.
Krug,
Yes.
McDonald,
Yes.
McAlpine.
Yes. Next up is the approval of the minutes from our meeting on October 12th, 2020. Those were part of our packet. If anyone has any comments or suggestions, please let us know. If not, we would entertain a motion to approve the minutes as presented.
So moved.
Support.
Allen,
Yes.
Gesund,
Yes.
Krug,
Abstain.
McDonald,
Yes.
Euler,
Abstain.
McAlpine.
Yes. So next up then would be our first item, which is application PBA 920 for 3372 Coolidge Highway. It's a variance for canopy signs. Aver Sign Company on behalf of Sunoco Gas Station.
Yeah, so I'd like to reference my November 3rd, 2020 letter. This is a variance request from Aver Sign Company on behalf of Sunoco that's located at the southeast corner of Coolidge Highway and 12 Mile Road, right next to City Hall. The applicant is seeking dimensional variances to install canopy signs in excess of the permitted number of signs per frontage, also not facing a roadway and larger in area than permitted for the total property. The subject property is located in the Gateway District, which is located at the corners, intersections of the major intersections of the community. I wanted to give a little bit of background on the property itself as it may pertain to these requests. The property was developed as a gas station back in 2001, and the owner at the time had requested a site plan and special land use for the use. Part of the approval process from the Planning Commission at that meeting stipulated a number of conditions, and a couple of them are important to the request for the signs on the canopy. Two of the stipulations were that only neutral colors would be permitted. They would not be allowed to be primary colors, and any decorative walls, or I'm sorry, and no signage could be installed on the canopy. This item was identified and brought to my attention today, doing some additional digging into the property. So I apologize that it wasn't given sufficient notice to you, but it was important to make sure that it was part of the application, part of the discussion, and inevitably it'll be part of the approval or denial package. If any of the variances are to be permitted, it should be stipulated that the applicant will need to go back to the Planning Commission in order to secure site plan approval for the changes that they are proposing on the canopy itself. Additionally, and this part is included in your review letter, in 2003, the applicant was granted a variance to install 2 wall signs. This is in addition to the 80 square foot freestanding pylon sign that's on the property. So currently they have signage at the corner for the pylon sign that advertises not only the gas station, but also the Mr. Kebab restaurant that's located inside the building. They have 2 wall signs, one facing Coolidge, one facing 12 Mile, that advertises the Mr. Kebab sign. They were specifically prohibited from having any additional canopy signage per their site plan approval. So there are the standards of review that we have discussed at every single, for every single variance request that has come before the ZBA. Those are also included in your packet. The zoning board has the determination to decide if a practical difficulty exists on the property, and if so, to grant them the variance. But I would caution or stress that any approval must be met or conditional on the approval of the Planning Commission for the amended site plan. With that, I'd be happy to answer any questions.
Seeing as does not appear to be any questions, is it now? Now should I make the public comment, Aaron?
If none of the board members have any questions for staff, then you should ask the applicant who is present this evening if they would like to make any statements.
Okay.
And then
So
we'll have a public hearing.
okay, so before we do that, are there any additional communications that we received? Okay. So with that, are there any members of the ZBA that have any questions?
Yes, I do. In terms of procedurally, if we decided to send this back to the Planning Commission for their ultimate approval, can we set this aside this evening so the applicant doesn't have to come back and pay a second set of fees?
Well, they would have to come back regardless. So
Right.
It's a matter of them coming before you now or going to Planning Commission first with this new information. So they would still need, no matter what, they would still need variances from the ordinance, which specify how many signs you can have per frontage. There's the south facing sign that doesn't face frontage at all, and then the access of square area of the signage that they're requesting. So whether they got the Planning Commission first, they would still have to come to the ZBA. So we're doing it this way round, because if the ZBA determines that the canopy signs are not granted their variance, there's no need to go to the Planning Commission.
Okay, thank you for clearing that up for me.
So if I may, this is just regarding signage on the canopy. The gas station canopy is still going to be there. They're not changing that structure at all. This is just adding signage to the canopy.
Part of, yes, that is the request, is that they're going to be adding signage to the canopy, yes.
But the canopy has been in existence and been the same size, and they're not making it larger or smaller.
No.
Okay.
Okay, so at this point, we would ask that the petitioner be allowed to speak on behalf regarding their request.
Jennifer or Naz, either one of you
Here
would
I
like
am.
to speak? Oh, hello.
Thanks,
Hi,
Jennifer.
sorry. Trying to get used to this whole Zoom thing. Excuse me. So I'm Jennifer. I'm with Aver Sign Company. Part of the reason that we would like to add the Sunoco signage to the canopy is it's part of the brand standard for Sunoco. Without the canopy signage, that goes against the contract that the station owner will have with Sunoco on supplying certain signage to the site. we think it gives it a much nicer, cleaner appearance. And it gives them some more visibility from every north, south, east, and west.
Is there anything else that you'd like to add?
No, I don't think I do. I was kind of surprised by the information that I received earlier today on the site plan and the special land use. So I wasn't really sure about that. Didn't know about all that.
Do you have some specific questions about that?
No, I don't. Excuse me. I spoke with Erin earlier regarding it, and I have an understanding of it. And we'll just have to take the information that I received back to the project manager so she can communicate with the fuel supplier as to how we need to go about handling this.
Okay.
Ms. Chairwoman, we do have, and I apologize,
No, you're good.
Naseem here. He also wants to speak as well.
That's great. Bear with me. This is my first Zoom leading on top of it. I mean, not my
You're
first
good,
meeting,
you're
but yeah. Okay, welcome.
Thank you very much. I'll be brief. Obviously, to touch on it on what we feel on our end, what this is, and is really just a standardization of most of the fuel centers that you guys see in the surrounding areas. To Jennifer's point, I mean, this is kind of in the normal operations of a Sunoco branding. I know this situation is not of norm, and I was relayed about the 2001 special land use that my father signed at that time, and I believe maybe at that time it was warranted, but also 20 years, there's obviously the landscape has changed a little bit. I mean, the city of Berkeley is flourishing, and I don't know, again, what the primary reason was with the neutral colors and the alignment. That's kind of above my, what the information I had. But just to touch on that, really, again, we're not increasing the size or changing the location of this canopy. It's really just to make it, the station itself uniform, which I think it will make it look better, which in turn, obviously, being at the center of the city of Berkeley would only add to that. So yeah, any way that we can, I mean, we will be very flexible. If there's certain things we need to do for this to fall under city code, we're obviously open to that. So, and yeah, that's pretty much it.
Okay, so do we have any questions? So at this point, seeing that there are no questions, I would like to open this up to public comment. And the public has the opportunity to speak on this item. And during this period, if you would like to speak, we would ask you to utilize the raise hand function by selecting manage participants in the bottom of your dashboard. Select the more button in the bottom right-hand corner. Our moderator will then call your name, unmute you so that you can speak. For those of you who have called in, you will be placed in queue for public comment by selecting *9. Our moderator will announce the last 4 digits of your telephone number for recognition. They will then unmute you so that you can speak. Every participant has 3 minutes to talk as if they were meeting in person, so that is the same rules we would follow then. Once your time is up, you will be muted by our moderator. And then additionally, comments can be submitted to zoning@berkeleymish.net. Residents and community members can submit their public comments. Your email must be able to be read in less than 3 minutes. Given the circumstances with virtual space, we may not be able to read through all the email comments, but know that we have them stored and acknowledge them in the record. To participate in public comments, you can dial by phone at 1-312-626-6799. Our meeting ID for this evening is 997-0652-8278. At this time, we will review any public comments and any correspondence. Do we have any of that at this point? So we do
Not at
not
this
have
time.
any. So we will give it maybe another 30 seconds and to see if someone's just, after hearing all the directions, is ready to engage.
Or I can get a 0 on it.
So having
Still
no
no-
comments, pardon me?
Nope,
I
go
was gonna
ahead,
say,
you're good.
Having no comments, we will now close that portion of the hearing and we will move to discussion on behalf of the ZBA members. Anyone have any comments or discussion or questions?
I do. I have a couple of comments. I understand that with a gas station, like any other business, they have standard message that they're going to put out. It's a consistent look for all of the locations. But unfortunately, this particular location has a lot of signage already and has the history of the actions that the planning commission took back then. And it's going to be very difficult to figure this out.
If I may, the lack of the signage it's basically a breach of contract with Sunoco to not have the Sunoco brand and colors be on the canopy. If there was some way to maybe reduce some of the signage on the building, would the canopy sign be in compliance?
You know, that's one of the questions that I have, because we have a directive from the Planning Commission back in 2001, was it, Aaron? Yes.
Yeah, the area of the sign was just one of the variances, one of the components that needs to be looked at this evening. The other is the fact that there are already signage on the wall. There's already signs facing Coolidge and 12 Mile in addition to the pylon sign, as well as there is one sign that's to be proposed on the canopy that's facing south, which does not face a frontage at all. So the area was one element and one component.
And, you know, I understand Mr. Gazun's point as well. It's a breach of, I don't know if it's a breach of contract. I haven't seen the contract, but at no point in time have I ever seen someone's marketing agreement trump the city's laws.
Yeah, I would say we have, as we've stated very regularly in every single one of these meetings, we have 5 clear standards that must be met in order to give someone approval for a variance. One of them simply being, by denying this, the property owner will not be able to use this property in a way that they would like. And first and foremost, the business is operating in a way that they would like to operate it right now. So that does pose another issue of how do we get around that, because even if we deny you, you can still continue to operate as you are, given it makes it a little more complex with your agreement with Sunoco, but that does not deny you from partnering with someone else, unfortunately. And we are often in a difficult position of having to make sometimes very challenging and challenging decisions that may not make a property owner happy, but it's part of what our job is.
Madam Chair,
Yes.
in looking at the standards for review, I look at B, and it says the need for the variance is not the result of actions of the property owner or previous property owners. Well, in this case, yes, it is. It was, the business has been passed from father to son, if I understand correctly. And this has been in place since the gas station was developed. What's there now currently from the Planning Commission. And also, there isn't anything, in my estimation, unique or a special physical condition on the property. It's a corner lot in downtown, and it's a pretty standard lot.
I guess I would, this might be a question back to the owner if that's possible, but I would like to give him an opportunity to explain what, if anything, has changed. I mean, the application just sort of references we're in breach of contract, and that of course begs the question, well, you have been for about 20 years, it seems like. So did something happen? Is Sunoco giving you problems, or what brings this on now? That's not clear to me, and I guess I'd like to hear that.
And you cut out a little bit, Mr. Euler, but basically, I had a very similar question.
Can you guys hear me?
Now we can. Go ahead if you want to restate your question.
Oh, crap.
Nope, now you're muted again, Mr. Mueller. So I don't want to put words in your mouth, but maybe you can just give us a thumbs up or something. But basically, your question is centered around the fact that this is now coming to us. If there is an existing contract in place, why are we now addressing this, given the fact that we're not sure of anything that has changed, and what brought this, why is this coming to us now?
I would be happy to respond if I am allowed to.
Sure, go ahead.
Thank you. Exactly to the gentleman's point, what's changed now is that the previous contract that was signed back in early 2000 has since been expired, and this is the new contract that you're signing with Sunoco. And Sunoco obviously has changed 100 times over from that way, just as that big of a corporate entity would. So that's why now they're coming with this whole new refacing and new branding, and with the new a new 10 plus year agreement. And I'd also like to point out I understand with the allotment of signage. To Mr. Gassan's point, we would be flexible again, just so we can just have this kind of uniform. We feel that it would be for the cosmetic betterment of the property itself. And the marathon on 12 Mile and 3427 12 Mile Road has the racing strip, the marathon racing strip on its canopy, and it has multiple signs on its exterior walls, like for example, like 2 big liquor signs, as well as I think the name of the location. So I don't know what has changed. I know that's a newer one. Again, I know all situations should be treated differently, but also being that close within the city, within downtown. I mean, again, it's just to try to just stay on pace with, everybody else.
Madam Chair, if I could ask Ms. Schluto a question.
Sure.
What are those two are those the same zoning district, the Marathon Station he spoke about and the Sunoco Station, or are they different zoning? Oh, you're muted.
They are different zoning districts. I did not look at what the marathon or any stipulations of how the marathon was developed. This information came to me this afternoon, so I was able to procure this for this particular site, and I caution using what other developments have been granted to do, because this one is specifically looked at in terms of the site plan and things of that nature. So I can't tell you how that one was developed. I only know how this one was developed.
I was more just interested in the zoning district, that
Yes, they're different
they are
districts.
different. So, okay.
I do have a question for the petition. What is your time frame in order to get these signs to be in compliance with your new agreement?
I would have to ask the sign company, or actually more importantly, probably our Sunoco rep for that information. I know they did want to begin as soon as they got their plans in order. I mean, but obviously if there can be some way we can resolve this and there's going to be some extra time, I'm pretty sure nobody's going to have any issues with that.
I guess where I'm going is, given some of this information has come in late this afternoon, I don't know if it's in the petitioner's interest to table this and see and review everything. And I don't know if there's something that they would come back differently.
Can I say something from the sign company? As far as having this work done, the plan is to have it done before it gets too cold. Otherwise, we have to wait until spring. So if we don't get it done fairly soon, then unfortunately, I don't know that it would be able to be done until after it thaws out.
Well, I guess my point is simply this: we can potentially vote tonight, given the information we have, that may not go in your favor. If you think it's advantageous for you to reevaluate the information that you have, and I don't know if that makes any difference, if there's any other opportunities you have, you may not risk us denying your request. And unfortunately, we can't control the weather. I'm just trying to give you all your
Right.
options.
What would my time frame be if we were to table it tonight and revisit this?
It would be at our December meeting, correct, Aaron?
Correct.
I don't know. I mean, we can certainly at the sign company reevaluate the signage and try to come up with a better plan between the building and the canopy to please the city.
If I may, is this scheduled to go before the planning commission, or it's waiting on what we do before that gets scheduled?
Yeah, it's waiting to determine if the variances are granted this evening, then they would be able to proceed with to go before the planning commission to request a site plan amendment. If the variances are denied this evening, then I would be discussing that with the applicant and the owner tomorrow morning to see if there's something else that we could work out.
But if this was to go before the planning commission, it wouldn't go before December anyway, right?
No, they could get on to the November one.
Okay. And then if it went through the
It's
planning
possible to get-
commission, then it could come back to us in December.
It's possible.
I have a quick question. Correct me if I'm wrong, but not only are these signs applied to the top of the canopy, they're also lit. Is that true? Is that a true statement?
Just the word Sunoco is what is lit, illuminated.
Okay.
Is there anyone else from the zoning board that has any comments or questions? Seeing none, at this point, we would ask for a motion or give the petitioner one last chance to have this tabled.
Could I request that we walk through the 5 standards
Sure,
to give
Great.
our feelings on that?
that's great.
Okay. Okay. Standard A, the need for the variance is due to unique circumstances or physical conditions of the property. I don't believe that's true, and I'd like to hear from the rest of my fellow zoning board of appeals members.
I would agree with you. I don't believe it meets it whatsoever either.
So before we go any further, and I appreciate you reading them, Mr. Allen, just because I don't have them pulled up in front of me. I want the petitioner to understand that in order to approve this, we have to agree that you meet all 5 standards. You can't meet 3 and not 2. It is straight across the board. All 5 must be met. And that is how we are governed in its law. So we have some very strict rules and guidelines in which we need to follow.
Okay, that being said, I'd like to make a motion that we deny PBA 09-20 3372 Coolidge Highway based on the fact that the standards for review have not been met.
I would support.
With that, we will take roll call, please.
Gazund,
No,
Krug,
Yes.
McDonald,
Yes.
Euler,
Sorry. Yes.
Allen,
Yes.
McAlpine.
Yes. Unfortunately, your request for a variance based on application PBA 09-20 has been denied for variances for canopy signs. Given that, I believe then, Aaron, you will be following up with them tomorrow.
Yes.
Perfect, thank you.
Thank you, everybody, for your time tonight.
Thank you. Thank you.
Thank you.
So next up then is meeting dates for 2021 calendar year.
This is an item that we look at every year. It's just looking ahead at the calendar dates for the following year and adopting them or approving them. So that way we have dates of record for everyone's reference.
Does anyone have any concerns about the dates as presented?
was there? I didn't see days presented.
It was in the packet that can,
I guess I lost it.
There's only one day that's off. That's the August meeting because there is a city council meeting that is proposed or is already scheduled to happen on Monday, August 9th. So we have pushed the ZBA date to Tuesday, August 10th.
so other than that, it's our normal meeting.
It's your normal second Monday of the month. Yep.
Yeah, and the list I'm looking at right now, it's printed out as August 9th still on the sheet.
Okay. I'm looking at it right now. It says August.
That was in the
10th.
packet that I opened.
Okay, so given the only exception would be the meeting normally scheduled for the second Monday, which would be August 9th, would be moved then to August 10th. Do we need a motion for that, or is this just kind of for our knowledge?
Nope, we need a motion.
Okay, so if someone would like to make a motion to accept the calendar as presented,
I'll make a motion to accept the calendar as presented.
Support?
Yeah.
Krug,
Yes.
McDonald,
Yes.
Euler,
Yes.
Allen,
Yes.
Gesund,
Yes.
McAlpine.
Yes. So next up is Mr. Hennanen, and he is going to give us some information regarding the Master Citizen Planner course.
Yes, thank you, everyone. Let me share my screen here briefly. This is my capstone presentation for completing the requirements to get the Master Citizen Planner credentials. You all will need to be going through the Citizen Planner course, the coursework. You won't need to go this far if you don't want to have to give a presentation to everyone. But tonight I'll be discussing making legally defensible zoning and planning decisions. So some of this might be review for a lot of you, but the part of the motivation is also that we have this as a living document or as a document for new members in the future. And then at the end, we'll make sure that my slides are available for review. So the things I'm going to cover are what types of decisions do we make? What are the legally required elements for decisions? What do the courts look for? And what are some of the best practices? But I need to start out by saying I am not a lawyer. Even though I'm talking about legally defensible decisions, we do have professionals. We have Ms. Schluto, our planner. We have John Starin, our attorney. So use these resources if you have any questions. It's going to be much cheaper to spend our attorney's time than it is if we do something improperly and have to defend a lawsuit. So when we look at the type of decisions that we have, they mimic the branches of state and federal government. We have legislative decisions, quasi-judicial decisions, and administrative decisions. Think of the executive branch with that. With the legislative type decisions, it doesn't come so much through this board, but council creates the laws that drive everything we do. The zoning map, the rezoning, the text amendments. But for all of these, the process starts with the Planning Commission. They take a look and then make a recommendation to City Council, who then makes the final determination. And then we have one kind of hybrid, the planned unit development. In Berkeley, it's legislative. It can be administrative elsewhere, but we've chosen to do it legislatively. So for a legislative decision to be defensible, this is going to seem sort of foreign and strange, but it doesn't have to be based on proven facts. And this legislator doesn't have to state their reasons. And the minutes don't record what is said. What is assumed is that the legislature knows what they're doing, that they have valid reasons for it, but they don't have to justify what those are. They are subject to legal tests. For example, is what they passed constitutional, but the courts aren't going to second guess what their motive were. And if someone wants to challenge a legislative decision, the burden of proof is going to be on them to show that they failed one of these legal tests, such as constitutionality. Now, the next type, and the type that's going to be most common in front of this board, is quasi-judicial decisions. Quasi means apparently, but not really. So it's kind of like a court, but it don't follow all of the strict rules of a court, and it's less formal. Though there are still rules of fairness that have to be followed, and we'll talk a little bit more about that later. So some of the quasi-judicial decisions are making interpretations of the zoning ordinance, whether it's the text of the zoning ordinance or a map, looking at variances like we did tonight, or hearing appeals. When you hear an appeal, you can only determine if the original decision was made properly or not, and if that decision was made, how relates to the ordinance standards. And anybody that's making an appeal in the city, they have to do it to the ZBA before they're able to go on to circuit court. Then the last category of here is administrative decisions, and that's just administering the law. It's almost a checklist, almost, but not quite, because sometimes there's some nuance and subjectivity in checklists, but we'll hit on that a little bit more detailed also. But if an administrative decision, if something meets the requirements in the zoning ordinance, then it must be approved. There's no discretion at all. And this is required by the Michigan Zoning Enabling Act. But we'll talk about this later. You can impose reasonable conditions to be able to get them across the finish line. So administrative examples are the staff or planning commission and several of the things they do, the site plan review. The planning commission generally does that, but there's some limited circumstances where staff can do a site plan review. And if the applicant doesn't like what staff decides, they can appeal that decision to the full planning commission. Lot splits, that's a staff decision, and those are usually straightforward. That's a yes or no. But if for some reason they wanted to appeal, that appeal would come before the ZBA. And then a special land use, that goes to the planning commission for their recommendation. And this is one of the few times where city council would approve or deny, and they're acting in an administrative capacity when they're looking at special land use, not in their legislative capacity. So what are the things that go into making these quasi-judicial and administrative decisions? So there's findings of fact, there's the reasons that get you, what is the decision-making that gets you from your findings of fact to the ordinance standards that drive everything that we're looking at. And then there is finally a decision. Did they meet the standards and that leads to an approval, or did they not meet the standards and it leads to a denial? And then you can kind of decorate that with any conditions for approval just to help them get there if they make some small changes. So our findings of facts, these are just factual issues that are used as the basis of everything else. They aren't things that can be imaginary or theoretical. It's not like you can't say, if we do this, maybe it'll be a problem. I really don't know, maybe it'll be a problem. You must be willing to state, if we allow this, it will be a problem for this reason. So an example I'm going to use is about a year ago, the former Farinas came for a special land use for outdoor seating for their area restaurants, or for the restaurant. And one of the things that was one of the finding of facts was that the Republica restaurant, which is nearby, has outdoor dining area that's very popular during warmer months. So that's a fact. And we can use that as we look at the ordinance standards and make our decisions. Now, when we're making findings of fact, they don't have to be in the motion to approve or deny. They can be such as the planning directors, will adopt the planning director's staff report as the findings of fact. Or you can have a separate motion that says, here are the things that the facts that we found. It's even possible, if it's a complex issue, decide what the facts you want to review are and wait until the next meeting to make your decision so you have time to digest and think about those. But it's these hard facts that everything else stems from. And we apply those facts to our ordinance standards. And with the ordinance standards, there's two different types. There's non-discretionary. These are things that are black and white. There's something you can count or measure. You know, it's like the building height, the lot coverage, the number of windows, how big the windows are. Those are things that you can enumerate and, you know, it's a yes or a no. But then there's other things that are ordinance standards that are discretionary, like compatible with adjacent land use. So that isn't a clear black and white. There's some shades of gray there that requires, you know, some objective thinking. So when we take our facts and apply reasoning to our standards, we kind of have to look, do the facts that we have support the standards in the ordinance? And the standard we should be looking at is preponderance, you know, preponderance being greater than 50%. And, you know, as we discussed tonight, you need to look at each and every standard in the ordinance. One standard that I think is often confusing is unnecessary hardship. And an unnecessary hardship isn't a hardship for the applicant. You know, it's a hardship for the property, something that makes the property unusable. But if it's related to cost or inconvenience to the applicant, that isn't a hardship in the meaning of it here. So going back to our Farina's example, you know, the ordinance standard is the proposed use is compatible with adjacent land uses. So we have the proposed outdoor dining area is compatible with adjacent land uses, as the Republic restaurant to the south has an outdoor dining area that's very popular during warmer months. So once you've taken those facts and looked at the ordinance standards, you need to make a decision. You can approve with conditions, or deny. And if all of the standards are met, you must approve. You have no discretion. If they meet the standards, even if you don't like the project, if you don't like the applicant, you have to approve it anyway. But if they fall short, but you can add reasonable conditions that would then allow the standards to be met, you should approve it with those conditions. We'll talk a little bit more about conditions here shortly. And then if any of the standard cannot be met, then it must be denied. So an example motion to approve could be, I think actually I quoted this, the Planning Commission recommends approval of the special land use for outdoor dining at the proposed restaurant to be located at Coolidge based on the plans dated based on the following findings of fact and subject to the following conditions. So I don't think I quoted that, but that could be an example of, you know, a motion to approve. And you don't have to list all the findings of fact. You can, you know, say the conditions that we discussed, but that's sort of the general framework. And now when you are giving your decisions for a reason, I would suggest explicitly stating, you know, each standard, this is why it was met, or this is why it wasn't, so that that is part of the record. Now, like we had discussed, you can add conditions, but the conditions you add have to be related to the actual ordinance standards. You know, a good one would be add screening to prevent headlights from a parking lot into the neighborhood. You know, that's related to being compatible with adjacent land uses. But bad, I know lots of people want a Mexican restaurant, but you can't make a condition that, you know, outdoor seating, you get your outdoor seating only if you serve Mexican. So none of our ordinance relate to type of food, so that just would not be an acceptable condition. So one thing to think about, is my condition reasonable? It's, could the standards be met without the condition I'm trying to add? If it's yes, then you can't add that condition. So back to our screening example, we can't say I want to add screening because I think it'll look pretty. Well, we don't have anything about it looking pretty. It must be related to a standard such as protecting adjacent land use. And the conditions also have to have what's called an essential nexus, some connection between the demand and the harm being addressed. An example would be a development is going to require digging up a public roadway for utilities, perhaps. And a valid condition is that you have to replace the road into its original condition. Invalid would be you have to replace the entire block, even where it's not disturbed. You can't use the conditions as a way to try and exact something extra out of the applicant that would benefit the city, but isn't related to the ordinance standards that you're trying to meet. And then the conditions, the costs have to be roughly proportional to the scope of whatever that harm is you're trying to prevent. So if the issue is stormwater runoff, it might be okay to say, we need to leave some green space for stormwater mitigation. But we can't say, and then you have to develop that green space into a park for the city. That is going too far. The public park part of it doesn't address the protecting the environment with the stormwater mitigation. Now, if somebody wants to appeal cases to the courts, the circuit court is going to look at if the decision was authorized by law, that is, met our standards, and was it supported by competent, material, and substantial evidence on the whole record. So we're going to be talking about what the record is. They are only going to review what's in the record, what's in the minutes, the related materials that are included. They're not going to, except in some extreme cases, dispute the findings of fact. The courts are going to trust that the people on the ground have a better grasp of the facts, even if it's a debatable issue. So they might dispute the interpretation of the law based on those facts, but they're probably not going to question the facts that you found. Because the courts will only look at the record, it's imperative that we have a good record. If something is not in the record, it just does not exist in the court's eyes. And we can't introduce new facts or new reasoning into the record at a court hearing. And in fact, if the court finds the record inadequate, they may send the case back, remand the case is what it's called, back to the city to it to be heard again and a better record be made. So what are the things that go into a good record? Proof that all of the due process steps have been followed. Did we comply with the Open Meetings Act? Did we give the proper notifications? We have all the minutes and the related exhibits, copies of all the applications, attachments, maps, and then any follow-up records of inspections, violations, and so forth. So what goes into good minutes? They have to be written. Video doesn't count. We couldn't just share the video and say, here's our minutes. We need to, should include the location of the property, who said what, any exhibits that were shared, and any changes that were made to the exhibits during the meeting. For example, if, draw on it and, well, let's do that this way instead. It's going to need to include those core components I talked about at the beginning, the findings of fact, the reasons, the decisions, and any conditions. And really the purpose of the minutes is that someone that wasn't there needs to have a reasonable idea of what happened in the meeting. So due process is also very important. Although we aren't as, quasi-judicial decisions aren't as aren't as rigid as a court of law, we still have to give people some of their rights. Did they get the Open Meeting Acts? Did they get the notifications? What was the Planning Commission's recommendation? Was it timely? Did we listen to it quickly enough? Didn't make them wait forever and ever. And then ex parte communication, talking to people outside of the meeting. And we'll discuss that in more detail on the next slide. But if any of the important steps are missing, it's important to just stop right there and fix them before going forward. Example, recently we had a city council meeting where we were going to meet in closed session. We noticed at the very beginning of the meeting that our notice to the public did not properly discuss what we were going to be discussing in the closed session. So we tabled that closed session until we could do the proper notifications so that all the due process steps were there. Now this might be one of the most important slides in this deck, ex parte communication, meaning from one party. That would be someone coming to you and talking to you about a pending issue outside of an open meeting. It's important that all the discussion about an issue happened in the open meeting where everybody can hear. If you're hearing part of a story and your fellow board members don't hear that, they're not going to know all the information that's going into your thought process. And if someone has a disagreement with that, whether it be a board member or the public, there won't be any opportunity to rebut what you've maybe been told. So when you are thinking about decision-making, you can only consider the facts that were introduced at an open meeting. So now if somebody tries to talk to you outside of the open meeting, try and stop them, explain to them what ex parte contact is and why you can't discuss, and then ask them to attend the meeting or submit written comments that can be shared with everybody. One way to try and avoid this, one common way, is if you're going to site inspections, go alone, including without the applicant. That would be often a place where they'll want to try and chat you up and talk to you about an issue. But sometimes, despite your best efforts, it's going to happen anyway. And if it does, take detailed notes of what was discussed and then share it with everybody at the meeting. That way, everybody is on a level playing field. Another thing to consider is if you have a conflict of interest. So it can be a conflict if it impacts your finances, if it impacts your proximity to the property. So the minimum standard would be if there's a hearing on a property that is next door to you, you almost certainly shouldn't hear that case. But if it's down the block, is it a conflict of interest? Starts to get in the gray area. Maybe it is, maybe it isn't. And then cases hearing relatives. If it's an immediate family member, you probably shouldn't hear that case. Is it your cousin? Maybe you don't talk to your cousin. Maybe you don't like your cousin. So it might not be an issue. But so sometimes they're black and white. Sometimes it requires some judgment to decide whether you need to bow out of the case because of a conflict of interest. Then just a couple of other potential pitfalls. We do allow someone to sit on both the Planning Commission and the ZBA. We don't have a member like that now, but voting on the same issue twice is something that shouldn't happen. Then also speaking on a publicly controversial issue before it becomes before your body. You do have free speech rights, can't prevent you from doing it, but it could cause problems if it gives the appearance of bias if anybody were to challenge the case. So then I just want to finish with the things that will keep you out of trouble. Having findings of facts, your reasoning, and a good record of all of that. Make sure that your decisions relate directly to the ordinance standards. Make sure everybody has due process, and then training. I'll just end with this quote from the Michigan State University Extension. Research done in the western part of the United States shows that initial training and continuing education in planning and zoning is one of the most effective risk management strategies a local government can employ. So, that's one reason I think training is a very important part of everything we do, and presentations such as this. Again, we have these slides will be available, and these are a lot of the resources that I used, links to them for further reading if you're interested. And that's all I have. Does anybody have any questions?
No questions, but it was a really good presentation. Thank you, Dennis.
All right.
Yeah, thank you, Dennis, for good, resourceful, educational presentation.
All right. Thank you.
Very good. Nice, short, sweet, but packed with good information.
I would agree.
Okay, thank you again for that. Moving on, is there any other business? Okay, Mr. Hennon, do you have or Councilman Hennon, do you have a liaison report for us this evening?
Yeah, just two things. One, Ms. Schluto, her recent update that she provided to the Planning Commission, ZBA, and Council with the goings on from the past, most of the past year. If you haven't reviewed that, that has a lot of updates and a lot of the things that I would normally update you all on. The only additional thing is the marijuana applications. The appeals process is going on, and we're anticipating that City Council will hear those appeals. Essentially every person that lost appealed. So we will have 30 some to hear. And yeah, so after that, then the marijuana applications will probably be finalized unless somebody gets knocked out of the top, and then they will probably appeal. So, but we are nearing completion there. So, but that's all I had. Thank you.
Once again, I will open it up and see if there is anyone from the public who has either called in, emailed, or is in the waiting room to make a comment about our meeting this evening. They are shaking their heads. We do not have anyone from the public who wishes to comment on our meeting tonight. So with that in mind, I will close the meeting of Monday, November 9th, the electronic meeting of the Zoning Board of Appeals at 8:10. We will be adjourned.
All right.
Anything else?
Have a nice Thanksgiving, everyone.
You too.
Thank you.
Bye,
Happy
everybody.
Thanksgiving.
Thanks, everyone.